offender and the resulting felony. These two elements must be present. If these two elements are present, and there is praeter intentionem is always and always a mitigating circumstance. Because it is expressly provided for under Article 13 as a mitigating circumstance, that the offender has no intention to commit so grave a wrong as that committed. The son of the father failed to arrive home that night, and so the father looked for the son, could not locate the son. The following morning, the father asked his wife to look for the son. The mother went home with the said son. The father, upon seeing the son, was so angry that he used a piece of wood to hit the son repeatedly. The father was not satisfied. He brought the son to the farm, and he tied the body of the son to a coconut tree. And while the body of the son was tied to a coconut tree, the father hit the son repeatedly with another piece of wood. After a few minutes, he released his own son, and on their way home, the son fell on the ground, lost consciousness. When brought to the hospital, the son was pronounced dead. And so the father was prosecuted for the crime of parricide. The father argued he has no intention to kill his son. His act was only that of trying to discipline his son. Despite his argument, the RTC convicted him of parricide with the mitigating circumstance of praeter intentionem. He has no intention to commit so grave a wrong as that of killing the son. On appeal to the Supreme Court affirmed the conviction for parricide. However, Supreme Court said the RTC committed an error in appreciating the mitigating circumstance of praeter intentionem. Supreme Court said there is no praeter intentionem in this case. The first element, an intentional felony, has been committed. Parricide has been committed. Second element, there is a notable disparity between the means employed by the offender and the resulting felony. Supreme Court said the second element is absent. There is no notable disparity between the means employed by the father and the resulting felony. There is no notable disparity between the act of the father of repeatedly hitting the son with a thick piece of wood and thereafter the resulting felony of death of the said son. Since there is no notable disparity, praeter intentionem does not lie so as to mitigate the criminal liability of the father. The neighbor and the husband arrived home. When the husband arrived home, he saw his wife over the phone, and the wife was so happy. The wife was in fact giggling. So the husband became interested. Who is that person at the other end of the line? And so what the husband did, the husband hurriedly grabbed the cell phone from the wife. And the husband heard the voice of a man at the other end of the line. The husband was so angry. And because of this, he confronted the wife, who is the man. The wife said, just a friend. But the said husband was so mad, they had an argument. In the course of the said argument, the husband slapped the wife, who at that time was walking. And when the said husband slapped the wife, since the wife was walking, the wife lost control of her balance. The wife fell. And as she was falling, the back of her head hit the pointed edge of the dining table. The wife suffered hemorrhage. Thereafter, the wife died. But it is not only the wife who died. The fetus inside her womb also died. And so the father was charged, the husband was charged for the crime of parricide with an intentional abortion. The father said he has no intention to kill the wife. He has no intention to kill the baby inside her womb? Will his defense lie? In case of conviction, if you were the judge, would you give him the benefit of prayer intention? The defense of the husband would not lie. Even if the said husband does not have intent to kill, the fact that the wife died, intent to kill becomes a general criminal intent. Second, the act of the husband of slapping the wife is a felonious act. And the resulting felony, that is parricide, was a direct, natural, and logical consequence of his felonious act. Therefore, he is liable under the proximate cause doctrine. However, he should be given the benefit of greater intention. First element is present, an intentional felony has been committed. However, second element is absent. There is a notable disparity between the means employed by the offender and the resulting felony. No one could have foreseen that out of the husband's mere act of slapping the wife would die, the fetus would die. Since there is a notable disparity between the means employed by the said husband and the resulting felony, parricide with an intentional abortion, greater intention would mitigate the criminal liability of the said husband. So those are the three instances under Article 4, first paragraph. Under Article 4, second paragraph, criminal liability shall also be incurred by any person performing an act which would be an offense against persons or property were it not for the inherent impossibility of its accomplishment or the employment of inadequate or ineffectual means. Article 4, second paragraph is known as the impossible crime doctrine. An impossible crime is one wherein the act done would have been an offense against persons or against property, but it is not accomplished, either because of its inherent impossibility or because of the employment of inadequate or ineffectual means. An impossible crime is not in reality a crime, because the act did not ripen into a crime. However, because of the criminal tendency on the part of the offender, he becomes criminally liable for an impossible crime. For one to be liable for an impossible crime, the following are the elements. First, that the act done would have been an offense against persons or property. Second, that the act was done with evil intent. Third, that the act is not accomplished because of its inherent impossibility or because of the employment of inadequate or ineffectual means. And last element, the act does not fall under any other provision of the revised penal code. These are the elements of an impossible crime. Based on the first element, an impossible crime would only lie if the act done, had it been accomplished, would have amounted to a crime against persons, those under Title 8 of Book 2. Parricide, murder, homicide, physical injuries, mutilation, etc. Or a crime against property, those under Title 10, robbery, theft, estafa, malicious mischief, etc. So an impossible crime would only lie in cases of crimes against persons, crimes against property, had they been accomplished. Second element requires the act was done with evil intent. What you are punishing is the criminal tendency, perversity of the offender. Third element, the act is not accomplished because of its inherent impossibility. When you say inherent impossibility, it means under any all circumstances, the act would not ripen into a crime. And in the case of Intod versus CA, the Supreme Court said there are two kinds of inherent impossibility. We have legal impossibility, and the other one is physical or factual impossibility. There is legal impossibility when all the intended acts, even if accomplished, would not have amounted to a crime. And there is physical or factual impossibility when extraneous circumstances, unknown to the offender or beyond the control of the offender, prevented the consummation of the crime. These are the two kinds of inherent impossibility. The last element requires the act does not fall under any other provision of the revised penal code. An impossible crime is a crime of last resort. You can only file a case of an impossible crime if the act done by the offender would not have amounted to any other violation of the revised penal code. If the act done by the offender would have amounted to another violation of the RPC, that violation would be the appropriate charge and not impossible crime, based on the fourth element. The husband arrived home. Upon opening the bedroom, the husband was shot. He saw his own wife in actual sexual intercourse with another man. The husband left. He actually left the house. A week thereafter, he filed a case of adultery against the wife. During the trial of the case, when the wife was presented in court, the wife presented in court evidence, documentary evidence showing that she is not a woman. According to her, she was a transgender. She was born male but had sex change. Thereafter, he married the husband. And so according to her, adultery would not lie. Based on this testimony, supported by documentary evidence issued by the doctors that caused the sex change, the judge convicted the accused of impossible crime of adultery. Is the judge correct? The judge is wrong. There can never be an impossible crime of adultery because adultery is punished under Title 11. Adultery is a crime against chastity. And an impossible crime would only lie if the crime, had it been consummated, would have amounted to crimes against persons and crimes against property. Therefore, the judge was wrong in convicting the accused of an impossible crime of adultery. The houseboy was mad, very mad at the master of the house. The master of the house was cruel to him, would always embarrass him. He had long wanted to kill him. One time, this houseboy saw the master got out of the house, went to the garden, and lay down on the bench. That was about 7 o'clock. When the houseboy again got out of the house, he saw the master still lying on the bench. 2 hours had already passed. It is now 9 o'clock. And there he was, still lying on the bench. And so, what the houseboy thought, it was his opportune time to kill the master. And so the houseboy slowly went, tiptoed, going to the said master, who was lying on the bench, and thereafter, with the use of a rake, he hit and hit the said master until the master, he believed, died. But based on the autopsy report, even before the act of the houseboy of hitting the master had long been dead for 2 hours based on heart attack. Is the said houseboy liable of any crime? The houseboy is liable of an impossible crime. The act done would have amounted to murder, a crime against person. The act was done with evil intent. The act is not accomplished because of its inherent impossibility. What kind of inherent impossibility? Legal impossibility. Even if all the elements of murder had already been done by the said houseboy, it would not have amounted to murder because the victim is no longer a person insofar as criminal law is concerned. The last element, the said act does not fall under any other provision of the RPC. Therefore, the said houseboy is liable for an impossible crime. The employee was instructed, the employee was instructed by the treasurers of the company to collect a check from a client. And so, the said employee went to the client, he collected the check, and then thereafter, instead of remitting the check to the company, to the treasurer in particular, he deposited the check to this account. But the check bounced. And so he was not able to get the face value of the check. But when the company learned of what he had done, the head of the company was so mad and a case of qualified theft was filed against the said accused employee. Is the accused employee liable as charged? The accused employee is not liable as charged. He is not liable of qualified theft. Instead, he should be liable for an impossible crime of qualified theft. The first element, the act done would have been an offense against persons, qualified theft. The act was done with evil intent. There was intent to gain. He deposited the check meant for the company to his own account. Third element, the act is not accomplished because of its inherent impossibility. What is present is physical or factual impossibility. Unknown to the said employee, the check was not funded. There is no sufficient funds. And the last element, the act doesn't fall under any other provision of the said. The act doesn't fall under any other provision of the revised penal. All the elements are present, therefore, the crime committed is an impossible crime of qualified theft. Why not qualified theft? Isn't it that he took the check? By the mere act of taking the check that is meant for the company, there is only intent to gain in the act of taking another person's personal property. The Supreme Court said that in case of theft or qualified theft, it is necessary that the thing taken must have value because of the element of intent to gain. Here, the thing the employee took has no value. The check is a worthless check. Therefore, it would not be qualified theft. It is only an impossible crime of qualified theft. X was walking on his way home. A holdupper appeared in front of X. The holdupper pointed a knife at X and told X, "You give me your watch. If you will not give me your watch, I am going to stab you." Afraid, a knife was pointed at him. And so, what X did, he gave the watch. And thereafter, he ran away. And the holdupper allowed him. He was only after the watch. He looked at the watch, he liked it. It looks like the watch that he lost a few weeks ago. He looked further at the watch, and there he saw, indeed, it was his watch. There was his name engraved on the wrist of the said watch. It was his watch. Finally, he got his watch. Is he liable of an impossible crime of robbery? First element, that the act done would have been an offense against persons or property. The act done would have been an offense against property, robbery, because the act of taking was done with intimidation with the use of a knife. Second element, the act was done with evil intent. He wanted to take the personal property of another. Third element, the act is not accomplished because of its inherent impossibility. What kind of inherent impossibility? Legal impossibility. Even if you perform all the acts, all the elements of robbery, robbery would not arise. Reason is, the thing taken by him belongs to him. It is necessary in robbery that the thing taken must belong to another person. How about the fourth element? The fourth element, the act does not fall under any other provision of the RPC. The first three elements of an impossible crime are all present. However, the last element is absent. The said act would have amounted to grave coercion, in particular, compulsive coercion, compelling someone to do an act against his will. He compelled X to give the watch to him by means of violence against or intimidation of persons. Therefore, the appropriate charge is not an impossible crime, but rather it would be grave coercion under Article 286. Under we go to Article 5. Earlier I said, nullum crimen, nulla pena sine lege. There is no crime when there is no law that defines and punishes the act. The base of that is Article 5. Under Article 5, when there is no law that defines and punishes the act, the only jurisdiction of the court is to dismiss the case. Likewise, under Article 5, when the offender has been charged in court, and based on the assessment of the judge, the penalty prescribed by law is too harsh to be imposed on the offender based on the circumstances of the commission of the crime, the judge should nevertheless impose the penalty as prescribed by law. However, the said judge can propose to the President through the DOJ that this person should be given an act of clemency by the President. We go to Article 6. Article 6 provides for the stages in the commission of a crime. Before that, there are two phases in the commission of a felony. We have the so-called subjective phase, and the other one is the so-called objective phase. The subjective phase in committing the felony is the start of the commission of the felony up to the time that the offender still has control over his acts. The offender may or may not proceed with the commission of the crime. He may proceed or he may desist. It is in the subjective phase. The moment the offender passed the subjective phase such that he no longer has control over his acts, he is already in the objective phase of committing the felony. There are three stages in the commission of a felony. We have the attempted stage, the frustrated stage, and the consummated stage. A felony is attempted when the offender commences the commission of a felony directly by overt acts and does not perform all the acts of execution that would produce the felony by reason of some cause or accident other than his own spontaneous desistance. The elements of an attempted felony are first, that the offender commences the commission of a felony directly by overt acts. Second, he was not able to perform all the acts of execution. Third, reason, he was not able to perform all the acts of execution by reason of some cause or accident other than his own spontaneous desistance. The first element requires that the offender commences the commission of a felony directly by overt acts. Based on this first element, the said felony committed must be directly connected to the overt act performed by the offender. So Supreme Court said, the attempted felony that is punished by law is one which is directly connected to the overt act that he performs, even if he has a different crime in mind. So the basis of the attempted felony is the overt act done by the offender. Second element, he was not able to perform all the acts of execution. And the third element, what is the reason? By reason of a cause or accident other than his own spontaneous desistance. So if the reason for the non-accomplishment of the crime is his own spontaneous and voluntary desistance, then he incurs no criminal liability. Desistance negates criminal liability in the attempted stage of a felony. But desistance would not negate criminal liability in the frustrated and consummated stage, only in the attempted stage of committing a felony. A felony is frustrated when the offender performs all the acts of execution that would produce the felony as a consequence, but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. So the elements of a frustrated felony are first, that the offender performs all the acts of execution to produce the felony. Second element, the felony nevertheless was not produced by reason of causes independent of the will of the perpetrator. So how would you distinguish an attempted felony versus a frustrated felony? The following are the distinctions. First, in an attempted felony, not all acts of execution had been done. The offender merely commences the overt acts, whereas in the frustrated felony, the offender had already performed all the acts of execution. Nothing more is left to be done. Second, in case of an attempted felony, the felony was not consummated by reason of a cause or accident. other than the offender's desistance. Whereas, in case of a prosecuted felony, the felony was not consummated by reason of a cause independent of the will of the perpetrator. And third distinction, in case of an attempted felony, the offender is still in the subjective phase of committing the felony. Whereas, in the prosecuted stage, the offender is already in the objective phase of committing the felony. He no longer has control over his acts. So those are the distinctions: attempted felony versus frustrated felony. A felony is consummated when all the elements necessary for its execution and accomplishment had already been performed by the offender. So when all the elements of a felony are already present, the felony is already in the consummated stage. X wanted to rob the house of Y. Y came home from abroad, from a foreign country, and X believed Y has many dollars with him. And so he wanted to rob the house of Y. He waited for night time. The moment it was already 11 o'clock, and X felt the people in the house of Y were already fast asleep, the lights were already out, and the community was in silence already. X went near the house of Y. Gradually, one by one, slowly, he removed the jalousies on one of the windows of the house and placed it on the ground. After removing about 5 jalousies, he believed it was sufficient for him to enter. The said opening would already fit his body. He was about to enter, but a police car passed by. He was in the act of trying to enter, and he was apprehended by the police officers and brought to the police station. After investigation, he was charged with a crime of attempted robbery. If you were a judge, would you convict him as charged of attempted robbery? He should not be convicted as charged of attempted robbery. What crime has been committed by him? It is only attempted trespass to dwelling. It is attempted trespass to dwelling because based on the first element of an attempted felony, the offender commences the commission of a felony directly by overt act. The overt act done was trying to removing the jalousies of the said window, making an opening sufficient for him to enter, and he was in the act of entering. Therefore, the overt act is the act of entering. The said act of entering is not directly connected to robbery. It is only directly connected to the act of trespassing. Therefore, he cannot be liable for attempted robbery but attempted trespass to dwelling, based on the first element of an attempted felony. X and Y were on board the jeepney. While they were on board the jeepney, suddenly X realized that his bag became heavy. And he felt that there was something inside his bag. And so when he looked at his bag, he saw the hand of Y. Before Y was able to get anything, X held the hand of Y and called the police. Y was not able to take anything. What crime has been committed by Y? Y is liable for attempted death. But what if both X and Y were on board the jeepney? X was fast asleep. He saw this big bag of Y. And so what Y did? He placed his hand inside the bag. He wanted to take any of the contents inside the bag. There must be the cell phone, the wallet, anything. But the bag was empty. He was not able to take anything inside the bag. Is he liable of any crime? He is liable for an impossible crime of theft. Under the first problem, it is attempted theft. It is attempted theft because the act of Y placing his hand inside the bag of X is an overt act directly connected to the act of taking, the act of theft. However, He was not able to perform all the acts of execution amounting to theft because of the early discovery on the part of the owner of the bag. He felt the bag was heavy and he saw the hand and he held the hand. Therefore, it is attempted theft. In the second problem, it is an impossible crime. Why place his hand inside the bag? One thing, trying to get anything, but the bag was empty. Under any and all circumstances, he could not take anything because it was empty. Simply, there was nothing to take. Therefore, it is an impossible crime because under any and all circumstances, the crime of theft would not be consummated. There is the inherent impossibility to consummate the crime of theft. What is present is the so-called physical or factual impossibility. Extraneous circumstances unknown to the offender prevented the consummation of the crime. X. In the course of a fight, X with a bolo tried to hack Y, but Y evaded the blow. X with intent to kill tried to hack Y, but Y evaded the blow. Y was not hit. Is X liable of any crime? X is liable for attempted homicide. The fact that he tried to hack Y with intent to kill, even if Y wasn't hit, such is already an overt act directly connected to homicide. However, he was not able to perform all the acts of execution that will bring about homicide because it was purely a cause that Y was good in evading the blow. X and Y are fighting. In the course of the fight, with intent to kill, X tried to hack Y. Y was hit near the neck. Y was brought to the hospital. Y sustained a non-fatal wound. A slight wound. What crime has been committed by X? X is liable for attempted homicide. Why not slight physical injuries? Because in the problem it says he hacked Y with intent to kill. Therefore, even if the wound sustained would heal only within a period of 2 days, amounting to slight physical injuries, since the act of hacking was done with intent to kill, it is attempted homicide. X, in the course of a fight, tried to hack Y. Indeed, he hacked Y on the chest. Y was hit on the chest. The doctor said it was a fatal wound. An immediate operation must be performed, otherwise Y would die. After the operation, Y survived. What crime is committed by X? X is liable for frustrated homicide. Since the wound inflicted by X on Y amounted to a mortal wound, a fatal wound, sufficient to bring about death, but death did not supervene because of immediate medical intervention, then X will be liable for frustrated homicide. The Supreme Court said that in case of intentional killing, whether it be parricide, homicide, murder, in order to bring about a frustrated felony, it is necessary that the wound inflicted by the accused on the victim must be a mortal wound, a fatal wound, sufficient to bring about death. Because it is only upon the infliction of a mortal or fatal wound that it can be said that the offender had already performed all the acts of execution that will consummate the felony of homicide. If the wound inflicted by the accused on the victim is a non-fatal or non-mortal wound, it is only in the attempted stage. Reason is, there must be another blow in order to consummate the crime. By inflicting a non-fatal wound, the offender has not yet performed all the acts of execution that could bring about the death of the said victim. Is there such a crime as frustrated? Is there such a crime as frustrated impossible crime? There is no frustrated impossible crime. There cannot be a frustration in impossible crime because in impossible crime, the offender had already performed all the acts of execution. Nothing more is left to be done. But the crime was not consummated because of its inherent impossibility, either legal or physical or factual impossibility. there are certain crimes which do not admit stages. Do not admit, the frustrated stage. We have rape. We have also theft. Theft, as held by the Supreme Court in the case of People versus Valenzuela, had only 2 stages. We have the so-called attempted stage, and the other one is the so-called consummated stage. Supreme Court said that there cannot be a frustrated stage in the crime of theft because in theft, as defined, it is committed when the offender takes the personal property of another with intent to gain, without the consent of the owner, without violence against or intimidation of persons or use of force upon things. Supreme Court said the act of taking is the only operative act necessary to consummate the crime of theft. The moment the act of taking is complete, theft is already consummated. And the act of taking is deemed complete the moment the offender gains possession of the personal property of another, even if he has no opportunity to dispose the said property. The same is true in the case of rape. In the case of rape, the Supreme Court also said that there is no such crime as frustrated rape. The reason is that according to the Supreme Court, under Article 266(a) of the Revised Penal Code, rape is committed when a man has carnal knowledge of a woman against her will. Supreme Court said the law used the phrase carnal knowledge and not sexual intercourse. Since the law uses the phrase carnal knowledge and not sexual intercourse, there is no need for full or complete penetration in order to consummate the crime of rape. Therefore, the slightest penal penetration already consummates the crime of rape. Hence, there cannot be a frustration in the crime of rape. The victim or X was sleeping. While X was sleeping, here comes Y, the accused. Y entered the bedroom of the said victim. Y undressed the victim, and then thereafter, he undressed himself. The victim began crying, asking for help, shouting. And so what the accused did, he covered themselves with blanket. And he tried to insert his penis into the genitalia of the said woman, of the said girl. However, the girl cried and cried, louder and louder, and so the man had to leave. And the testimony of the girl said that the penis of the accused naidikit to her genitalia. And so because of that, the RTC convicted the accused of rape. That is, consummated rape. The CA affirmed the conviction. Supreme Court, however, said the crime committed is not consummated rape, it is attempted rape. Supreme Court said, it is settled in jurisprudence that the slightest penal penetration consummates the crime of rape. And there is the slightest penal penetration the moment the penises touch the lips or labia of the pudendum of a woman's genitalia. When what the penises touch is only the outer surface of a woman's genitalia, but based on the facts and circumstances, there is on the part of the accused intent to lie with the victim, the crime committed is attempted rape. In this case, the said accused, based on the facts and circumstances, had the intent to lie with the said victim. And since the penises touch only the outer surface, therefore, the said man is liable for attempted rape and not consummated rape, according to the Supreme Court. In this case, also, the Supreme Court said that attempted rape is different from acts of lasciviousness, in the sense that in case of attempted rape, there is on the part of the accused intent to lie with the victim. In case of acts of lasciviousness, there is no intent to lie with the said victim. So, in that case, that is the case of People versus Pareja, the Supreme Court said the accused is liable for attempted rape based on the facts and circumstances. He had the intent to lie with the victim. However, there is no slightest penal penetration. What the penis touched was only the outer surface. This girl was a helper in the house of couple X and Y. While the girl was fast asleep, she was awakened, and he saw the master, the man on top of her. She realized she was already naked, totally naked, and the master was on top of her, kissing her breast. She struggled, and she kicked the master, and the master left. She filed a case of attempted rape against the master. Convicted up to the CA. When the case reached the Supreme Court said, it is not attempted rape, it is only acts of lasciviousness. Based on the testimony of the girl, the penis didn't touch. There was no slightest penile penetration. Why not attempted rape? Supreme Court said, there is no evidence that the erected penis of this man is possible of penetration. Absent that, Supreme Court said, the act of the man of kissing the girl, kissing the different parts of the body of the girl, the breast of the girl, the private parts of the girl would only amount to acts of lasciviousness. There was this truck. The truck was filled with different cargoes. While the truck was on the street, on the road, it was red light, and so the truck was in full stop. Here comes two boys, two men, and these two men boarded the said truck, and they took whatever they can and placed it inside their backpacks. Thereafter, they jumped out of the truck. However, they saw the police. And when they saw the police, they went back to the truck and placed everything that they had taken inside the truck. But the police arrested them. What crime has been committed by these two men? The two men are liable for consummated theft. What about the fact that upon seeing the police, they went back to the truck and returned everything that they had taken? That would not affect the criminal liability. That cannot be considered as resistance. If ever it is resistance, it is too late because resistance negates criminal liability only in the attempted stage, but not as in this case, the act of consummated theft. Theft is already consummated the moment these two men took part of the cargoes, placed it inside their backpack, and jumped outside the truck. At the time, theft is already consummated. The fact that they returned to the truck and returned the cargoes that they had taken, that act cannot be considered as resistance that will negate their criminal liability because theft is already in the consummated stage. The resistance will only negate criminal liability in the attempted stage. The fact that they returned it will only affect the civil liability but not the criminal liability of the said offender. There are last question, last bar. If the slightest penile penetration consummates the crime of rape, when is there attempted rape? There is attempted rape when what the penises touch is only the outer surface of a woman's genitalia. And based on the facts and circumstances, the accused has the intent to lie with the said victim. It is only attempted rape. If a crime admits stages, the said crime is considered to be material crimes. But if the crime doesn't admit stages, it is said to be formal crimes. So material crimes are those crimes that have attempted, frustrated, consummated stages, or either attempted and consummated stages. Whereas formal crimes are those which are punished only in the consummated stage. They have no attempted and frustrated stages. Example of formal crimes, we have adultery. Adultery is punished only in the consummated stage. Adultery is in the consummated stage upon the carnal union between a married woman and another man, not her husband. Physical injuries. Physical injuries are formal crimes. There are now attempted and frustrated physical injuries because physical injuries is punished based on consequence, based on result, not based on tendency. Slander, oral defamation, false testimony, they admits only the consummated stage. No attempted, no frustrated stage. If you stated slanderous remarks, it is consummated. Not stating anything, no attempted, no frustrated stages, because it is punished based on consequence, based on result. You need a break? You have 15 minutes break.
Thank you.